And that was the property went to the, and you correct me if I'm wrong, the property went to the wife in the will, but the kids were on the deed with the father as joint tenants with rights of survivorship, which means technically the ownership interest would go to them. So did I set that up correctly?
Yes. When I thought about that scenario, I'm like, okay, why did he do that? And that would have been my question. What was that rationale? And so, because the next thing he did is he had a will that said, when I die, I want the house to go to my wife. I'm like, okay, well, these two things are not equal. They don't, they're incongruent. And so what ends up happening is they could transfer the property, right, to the wife. But what happens, and I think your question is, well, the will said it goes to the wife, and I'm like, yeah, but joint tenants with rights to survivorship beats out the will.
I was going to say, because that is in the transfer of the title, so it makes it almost superior. No, not almost. It makes it superior to the will. What needed to have happened would be him to redo the deed and maybe do it with him and his wife as joint tenants with rights to survivorship, or remove the kids so it's just him and let the property transfer through the will.